what is special circumstances? How does a court assess special circumstances? Well, really, we're guided by the legislation. When I sit in the special circumstances list, and I do so generally when Angela Soldani is on leave, and believe you me, she deserves her leave, really there's got to be a nexus between the offending and the person's circumstances. On many occasions, the court will be handed reports which quite clearly indicate that a person is suffering from, let's say, a mental illness, is a subject of homelessness, etc., as defined under what would normally be special circumstances. But then there is no obvious nexus between that and the offending. In those circumstances, the court can't apply special circumstances. However, and I'm sure my colleagues, although I can't guarantee, but I certainly know Ms Soldani would do so, it does not mean to say that a person's circumstances wouldn't be taken into account. I must admit, I'm the first to put my hand up and say that I apply the definition fairly rigorously in court. But then again, on the evidence before me, the reports that are tendered, I'm not immune from considering the person's circumstances. And at the end of the day, the outcome, and I quite clearly say this in court, the outcome may not be anything different. You may not get a different outcome, whether it's special circumstances that I've found or I don't find. Because I think it normally just becomes a plea in mitigation, as with a normal plea as far as I'm concerned. One of the problems that I do know that a lot of legal counsel come across, of course, is the difficulty where someone has long-standing issues over many years and the matters before the court are quite old. They could go back 5, 6, 7 years. But of course, the report before the court is based upon a recent interaction with a health professional. That health professional is really dealing with sometimes an interview which might take 90 minutes, in which they are to make an assessment and a report for the court. And it is quite difficult for the court to then take into consideration, for special circumstances, the nexus, or find the nexus between the person's special circumstances and historical issues, historical offending. Again, that's where, notwithstanding special circumstances may not be found, the court would not be immune to giving due consideration to the person's current circumstances as disclosed by the report. I also refer to, I think there was a Supreme Court case of, it might be Mitchell, Justice Betty King, and she made it quite clear that the limited value of those in those type of situations of such reports. But again, as I said, you're quite entitled, the court's quite entitled to take a person's current circumstances into account. As far as the fines reform legislation is concerned, in terms of special circumstances, really the main focus in first instance is really on the director's assessment, and I'm sure you've heard all about that, Section 38. Surely someone's mentioned about Section 38, the enforcement review, and as Imogen's indicated, the referral back to the local council or the prosecuting council for them to make a decision. There's really only one, I think, one or two sections, Section 165, 167, and the time served provision, I think it's 171 capital C, where the court is obliged to take into account special circumstances, really it is a policy issue of the court. A lot of people probably don't realise this, but the special circumstances court itself is really a set up as a result of a policy decision as to how to deal with these matters. If you look through certainly look through the fines reform legislation, it's not until you get to the enforcement warrant stage there's that connection between the court and consideration of special circumstances. But I'm sure that, notwithstanding that, the old policy that we've adopted of having a central court for special circumstances will, wherever possible, continue, because I think it's been successful. But then again, it is a quite busy list. Angela Soldani spends a lot of time. She's very experienced in that list. As I said, I'm only in that list every now and then when she's on leave. But I think most people get a fair hearing in that list, and the matters are dealt with appropriately on their merits. To a certain extent, it won't change. Probably the hardest part as far as court administration is going to be is, in fact, coordinating the listing of special circumstances, and really that's not, although it's not a judicial function, I'm aware of the problems that the court is facing. As you well know, there's a dedicated list at Melbourne Magistrates Court who deals with special circumstances cases wherever the alleged offending may have occurred. To a certain extent, the control of those matters will be taken out, or have been taken out of the control of what is courts administration, because of, let's say for example under section 38, where the director has referred the matter back to the agency and the agency decides to issue a charge and summons, for example. That could be in central Victoria, or it could be at Geelong, or it could be at Dandenong, and of course the agency then has to issue a charge and summons. Now, in normal circumstances, the charge and summons is governed by the Criminal Procedure Act. There will be attempts to try and coordinate how those matters will be listed, but we really don't know, as Imogen said, what type of numbers we're looking at. And it will require, again, I'll be corrected if I'm wrong, a lot of cooperation with a lot of the agencies, particularly the local councils that normally prosecute matters, for their cooperation anyway, to make sure this is, runs along similar lines that it does at the moment.